Let's go now to our next submission online. Joining us by Zoom is Julian Batchelor.
Okay, so this is my oral submission. My name is Julian Batchelor. I represent StopCo Governance. The source document for this bill is the treaty, so my submission will focus on the treaty. The treaty has 5 parts: a preamble, an Article 1, Article 2, Article 3, and an affirmation. In this submission, I draw on facts and quotes from historians, and all quotes are academically referenced. So let's crack into it. I'm using the final English draft of the treaty written by James Busby and in his handwriting. Busby made it clear in his journals that the final English draft of the treaty was written by him in his handwriting, and this was accepted by Hobson. In every respect, this document fits the expected profile of the final English draft of the Treaty of Waitangi. Yet the Treaty of Waitangi in the Treaty of Waitangi Act 1975 Schedule 1 is not in the handwriting of James Busby. It's in the handwriting of someone called James Freeman, which means what? The government has the wrong English version of the treaty in the Treaty of Waitangi Act 1975. This explains why there is a big difference between the so-called English and Maori versions. Well, in turn, this has given rise to the need to invent principles to reconcile the differences. There would be no need for so-called principles of the treaty if the true bona fide English final draft of the treaty was in the Treaty of Waitangi Act 1975, because this final English draft and the treaty in Maori are a perfect match. That is to say, if the courts or Maori or MPs or the public want to know with 100% accuracy what the treaty in Maori says, they would only need to read the final English draft. So if you want to fix the issue of treaty principles once and for all, then for God's sake, use the final English draft of the treaty in the Treaty of Waitangi Act 1975. Amend the Act. Now to the preamble. What does it say? Well, there is the preamble. I'm not going to read it all, but there is the main point of the preamble. The British said they would set up a government. What exactly did the British agree to in the preamble? The answer is to set up a government in these islands. What kind of government? Answer: a democracy, albeit in seed form. As the infant colony grew, so the reality of democratic government also grew. And democracies have 3 great pillars: singular government, private property, security, equality of citizenship. Importantly, these are the 3 pillars of the treaty. What about Article 1? Well, this is what it says. The chiefs of the Confederation of United Tribes and the other chiefs see to, and I can't quite see because it's something's covering this, but that's what it says. You can see that your part of the screen is covered. Here in Article 1, the chiefs ceded sovereignty completely and forever. What does this mean? It means Maori handed over the complete control of the country to the British forever. Entire means entire, all of it. Not partial control, but entire control. Not the British only ruling over the British, but ruling over all citizens, including all Maori. Again, this is according to the plain reading of the treaty. When Maori talk of establishing a dual government, they are trashing their 1840 elders, breaching the treaty, and ought to be charged with treason, for this is what it is. In 1843, so the question is, how do we know for certain that Maori ceded sovereignty? Well, in 1843, inside the British Parliament, in a 3-day sitting on the question of New Zealand, Lord Stanley reported to his MPs. He said, quote, "It was a historical fact that in 1840 the Crown had asserted sovereignty over New Zealand. Consequently, it was incontrovertible," that's a key word, "that all New Zealanders, or that all of New Zealand and all persons inhabiting its territory lay within the dominion of the Crown," unquote. The dictionary defines the word incontrovertible as not open to question, indisputable. Conclusion: anyone who claims Maori did not cede sovereignty is living in denial, which is not just a river in Egypt. Interestingly, the British in 1840 sought out all the chiefs who signed Hei Whakaputanga, or the Declaration of Independence 1835, making sure they signed the Treaty of Waitangi. In other words, if the chiefs attained sovereignty in 1835, and that's a fact disputed by historians, they ceded it in the treaty 5 years later. On what authority do we say this? Renowned historian Dr. Matthew Wright says, quote, "The Declaration of Independence was accepted by the Colonial Office to the extent that its signatories were sought and collected for the Treaty of Waitangi, which superseded it." So that's pretty clear. There's another quote from Sir Aparana Nara, the greatest Maori we've ever had. He says that Maori ceded sovereignty. Now on to Article 2. This has 2 parts. The first sentence says, "The Queen of England confirms and guarantees to the chiefs and the tribes and to all the people of New Zealand the possession, that's the key word, of their lands, dwellings, and all their property. The key point I want to grasp here is that the English word possession was translated as Tino Rangatiratanga by missionary Henry Williams in 1840. Tino Rangatiratanga does not guarantee Maori ownership of their land in perpetuity. If Maori sold their land, they lost possession of it, the security transferred to the new owner. Imagine how ludicrous it would be if homeowners in New Zealand today could sell their properties, take the cash, spend it, and then demand that the government reissue to them the ownership of the land they just sold. It is also a complete insult to the British and to all New Zealanders that this idea is even being entertained in New Zealand under the flag of Tino Rangatiratanga. Such a demand would not only be laughable, but it's nonsensical. Yet these demands are made by activists today in the name of Tino Rangatiratanga, while MPs meekly nod in agreement, seemingly oblivious to the comical idea that they are agreeing to. I reiterate, if after 1840 Maori chiefs, iwi or hapu, sold their land, they lost possession of it. The historical record shows without doubt that from 1840 onwards, Maori went on to sell 92% of their land. It was not stolen, which is another Mount Everest-sized lie trotted out by activists with regular monotony today. It was sold. So when Te Pāti Māori leader WhangāreiTim uses Rangatiratanga, he uses it as meaning Maori sovereignty. In saying this, Rawiri is delusional. How could Maori cede sovereignty in Article 1 and then take it back in Article 2? Rawiri's ideas are also an absolute insult to the British. I therefore call on the government to affirm David Seymour's original second principle because it synchronises perfectly with the plain meaning of Sentence 1, Article 2 of the Treaty of Waitangi. That the government would honour all New Zealanders in the chieftainship of their land and all their property. Now to Article 2, the second sentence, which reads just like that. I'm not going to read it all, but the key idea in this sentence is the purchase of land by the British. What did the British promise Maori here to buy Maori land? That is all. Contrary to what activists and the media say today, the chiefs were hungry to sell their land. Acclaimed historian Dr. Bain Atwood reports, quote, there was a growing demand on the part of the natives to dispose of their land without government interference or control. So the twin narratives that we hear today that Maori would never sell their land and that their land was stolen, like I've said, is manifestly untrue. What about Article 3? It reads this: in return for the cession of sovereignty to the Queen, the Maori people of New Zealand shall be protected by the Queen of England and the rights and privileges of British subjects will be granted to them. When Maori in 1840 became British citizens, they automatically became equal before the law with all other citizens. The cry of Maori activists today to claim superior status over all other citizens has no foundation in the treaty. In fact, it's a massive breach of the treaty. Once again, when they say these things, their minds have drifted into what I call treaty fantasy land. Therefore, if politicians want to be faithful to the treaty and not themselves breach the treaty, they have no choice but to make David's third principle law, that all New Zealanders are equal under the law with the same rights and duties. Finally, there is no partnership in the treaty. I hope you notice that in the entire text of the treaty, there is no mention of partnership with Maori, or that the British would only rule over British settlers. Why are these ideas blatantly and obviously missing from the plain reading of the entire treaty? Answer: because those ideas don't exist in the treaty. They're simply not there. They're pure fantasy. They are modern day inventions. It is oxymoronic for a country to be a sovereign and have a partner. Partnership and sovereignty are mutually exclusive concepts. The idea that the treaty is a partnership is the greatest lie to ever come out of the courts. We ought to never accept their judgment when these judgments contradict the plain reading. Judges are not gods. They're just people, and people are fallible and very capable of corruption. I reiterate, there is no mention of partnership in the treaty. Any party or MP who says the treaty is a partnership is not just intellectually lazy, but they're also delusional or deliberately and knowingly lying to the people of New Zealand. Here's my summary. Finally, to the fifth and final part of the treaty, the affirmation. Here, the Maori chiefs signed that they fully understood with what I've just described in this submission. In summary, I support David Seymour's bill becoming law because his original three principles honour the Treaty of Waitangi in every respect. If the government is sincere with its claim to want to honour the treaty...
Julian, I'm sorry to interrupt. That's the 10 minutes for our time today. So on behalf of the... want to thank you for your submission and for your presentation.
Thank God.
Okay.
Utter rubbish.